Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Khushi Maheshwari. She is going to speak on Environmental Protection Act. She is from KES Sri Jayantilal H. Patel College of Law. So without wasting further time, I would request Khushi to commence with her lecture. Thank you.
Hello everyone. So today I am going to talk about one of the most crucial laws protecting our planet, the Environmental Protection Act 1986, introduced in the 42nd Amendment of the Indian Constitution, as well known as the environment. As we know that the environment is the foundation of our existence, and its protection is not just our responsibility but a necessity for the survival of our future generations as well. But what do you mean by environment? It includes water, air, land and other interrelations which exist among these and the microorganisms, the creatures in our society. In simpler terms, our surroundings. The Environmental Protection Act was enacted in 1986 in India as a response of the tragic Bhopal gas tragedy of 1984, one of the most crucial industrial disaster in the history. The tragedy, which resulted in thousands of deaths and long-term health impacts, highlighted the urgent need of strict liability and regulations for and preventive measures in our society related to environment. Recognizing the gravity of environment pollution and industrial hazards, the Indian government introduced this act under Article 253 of the Indian Constitution, implementing international environmental agreements. This act serves as an umbrella of the legislation that empowers the central government to take the measures to protect and improve the environment, prevent pollution and regulate hazardous activities. It allows the government to set standards for emission, regulate industries and take strict actions against those violating environmental norms. But why do we need such laws? The answer is simple: the climate change, pollution, deforestation and biodiversity loss that threatens our own existence. Air and water pollutions, improper waste disposal, and excessive use of our natural resources, and that's why we need this law for our own importance. Our ecosystem will continue to suffer if we do not imply any laws because people have been destroying the environment regularly. The Environmental Protection Act has played a significant role in strengthening pollution control boards, enforcing environmental clearance for industries and promoting sustainable development. However, the challenge is implementation and public awareness. Many industries and individuals continue to harm the environment, often due to the ignorance of the lack of enforcement. Now let us have a look on the objectives of Environmental Protection Act 1984. The primary objective of the Environmental Protection Act is, as the name suggests, protection. But protection of what? It is solely of human beings? No, it is about safeguarding the entire environment, which compromises both abiotic and biotic components. But what do you mean by biotic and abiotic components? Biotic components includes all the living organisms, human, plants, animals and microorganisms in fact, each one of which is interconnected within a delicate life cycle. Preserving these elements is crucial for maintaining ecological balance. Abiotic components. Abiotic components refers to the non-living organisms such as land, water and other elements which is important for ourselves. The resources which is significantly impacted human activities, often leading to ecological imbalance. Environmental protection is vital for preserving endangered species, preventing environmental contamination, conserving forests and ensuring the fundamental right to a healthy environment. Additionally, it plays a crucial role in maintaining ecosystem health, mitigating climate change and promoting sustainable development and making sustainable land management for a better and more balanced future. Some key points over here are protection and improvement of the environment. The primary objective of EPA, that is Environmental Protection Act, is to protect and improve the environment by preventing pollution, regulating industrial activities and promoting eco-friendly practices. The Act provides the government with the authority to take necessary measures to protect the environment from degradation. Prevention of control and pollution. Nowadays we see a lot of pollutions happening around us due to vehicles, from the air pollution, sound pollutions and many more things. But we need to prevent that. So we need, the central government is like empowered to set an environmental standards and monitor the compliance, because it is important for us to look into the pollution we are creating for ourselves and for the other animals as well. The third point is implementation of international environmental agreements. India is a signatory to various international environmental treaties and agreements such as the Stockholm Conference 1972. The Act provides a legal mechanism for implementing these international committees at the national level. Regulation of hazardous substance. The Act empowers the government to regulate and restrict the handling, storage and the disposal of hazardous substances to prevent risk of human health and the environment. Industries dealing with toxic materials must comply with safety guidelines. Next point is sustainable development. But what do you mean by sustainable development? Development which takes place in such a way that our future generations can also have the resources which we are using now. The EPA aims to balance economic growth with environmental protection, ensuring that the development does not come at the cost of natural resources and ecological balance. It promotes sustainable and eco-friendly practices, saving the environment for the future generations also. Establishment of environmental guidelines and standards. Act empowers the government to set scientific standards for emission discharge and environmental quality to ensure pollution control and minimize environmental damage. Power to take strict legal action and imposing punishments and penalties against violators. The EPA provides strict legal provisions to punish individuals or industries responsible for environmental pollution and degradation. Violators can face heavy fines, closure of industries, and even imprisonment. The punishment includes a prison term of up to 5 years and fine up to rupees 1 lakh or both. This can also be extended for up to 7 years in cases. Environmental awareness and public participation. Do you think we are participating in protecting our environment? The answer is no. We all know that protecting the environment is important, but are we doing that? No. The Act aims to increase the public awareness about environmental issues and encourage citizen participation in environmental protection. It also allows individuals and organizations to report violations and seek legal actions against polluters. Next point is rapid response to environmental hazards and disasters. So the case is the environment keep having problems in it, like any hazardous or disasters taking place cannot be solved as quickly, but the government nowadays are taking actions to solve it quickly. This act enables government to take immediate actions and preventive and remedial actions to minimize the damage. The next is, and the last point is, protection of biodiversity and natural resources. The EPA focus on conserving forest, wildlife and water bodies, recognizing their critical role in maintaining ecological imbalance. The Act empowers the government to declare eco-sensitive zones and regulate activities that may harm biodiversity. The Environmental Protection Act 1986 is a crucial law that provides a strong legal foundation for environmental conservation, pollution control and sustainable development in India. However, effective implementation, strict enforcement and active public participation is necessary to achieve this objective. This act served as a reminder that protecting the environment is not just for government's duty but for also the responsibility of us all citizens. Environmental issues can arise both at local and global level. If we talk about local environment problems, that is related to a specific areas or a geographical areas which is in a small part. Like if we talk about the example of the LA fires, that is a recent case, the Los Angeles fires. That was a local issue because that fire took place in Los Angeles, a smaller part of the world. But if we talk about Amazon rainforest fires, that result in significant biodiversity loss affecting the global ecosystem, and that cause global environmental issues just like climate change, ozone depletion and biodiversity loss impact the entire planet due to the widespread human activities. Environmental problems are interconnected and complex. Solving one might create new challenges. So if we go by the new example of EV cars, we are all looking for bringing EV cars, but what about the battery disposals? So the problem is petrol and diesel is creating problem. Solution is EVs, but that also creates a new problem, and that is all interrelated, creating interconnected problems, and it leads to complexity of environment issues. Environmental protection demands collective global effort. No single entity can address these issues alone. Organizations like UN plays a crucial role by setting environmental policies, facilitating treaties, conducting research, and providing platforms for international cooperation. While the UN cannot enforce laws directly, it influences the nation to adopt and implement the effective environmental regulations. Global collaboration is essential for a sustainable future. Not a single person can save the environment, but it needs effort for everyone. The Environmental Protection Act 1986 has been an instrument in shaping India's environmental jurisprudence, with several landmark cases, judicial pronouncements reinforcing the principle of sustainability, accountability, and public health. Let us have a look at few of the landmark judicial decisions under the Environmental Protection Act. Vellore Citizen Welfare Forum versus Union of India, 1996. This case marked a turning point in India's environmental law, addressing the severe pollution caused by tanneries in Tamil Nadu. The Vellore Citizen Welfare Forum, a non-governmental organization, filed a PIL under Article 32 of the Indian Constitution, highlighting the unchecked discharge of untreated industrial effluents in the Palar River, a vital drinking water source. The pollution has devastating effect on agriculture, aquatic life, and public health. The judgment stated the Supreme Court invoked the absolute liability principle, holding industry strictly accountable for environmental harm caused by hazardous activities, regardless of negligence. The judgment delivered under the Environmental Protection Act 1986 reinforced key environmental principles. Polluter pays the principle. This means the polluter, the industries who has been polluting these, has to pay the principal who has been going through this loss. Industries must bear the cost of environmental damages they cause. Precautionary principle, industries must take proactive measures to prevent environmental degradation. The ruling emphasized the judiciary proactive role in environmental protection and established a framework to hold polluters accountable, urging industries to adopt sustainable practices. The next case is MC Mehta versus Union of India, Oleum Gas Leak Case, 1986. Following the tragic Bhopal gas tragedy, another major industrial disaster occurred when oleum gas leaked from Shriram Food and Fertilizer Industries plant in Delhi, causing a fatality and severe health complications for many environmental lawyers. MC Mehta filed a PIL under Article 32, seeking closure and relocation of hazardous plants, which were located in densely populated area. The judgment was like it expanded the scope of Article 21, the right of life, which interpreted to include the right of a healthy environment, making any activity that endangers public health a violation of fundamental rights. Absolute liability principle, departing from the traditional strict liability, as seen in Rylance versus Fletcher, the court introduced absolute liability, holding industries completely accountable for any harm caused by them for their hazardous activities, without exceptions or defenses. Recognition of public interest litigation. This case strengthened the legitimacy of PILs, ensuring greater access to justice by allowing concerned individuals and organizations to advocate for environmental protection on behalf of affected communities. These landmark cases underscore of India's commitment to environmental justice, reinforcing the responsibilities of industries to adopt sustainable practice and ensuring strict legal accountability for environmental harm. They also highlighted the power of judicial activism in upholding the fundamental right to clean and safe environment. Moving forward, let us look at the flip side of this Environmental Protection Act. There is a huge conflict between development and environmental protection. The need to protect the environment has sparked several controversies, particularly as rapid development demands increase resource consumption, while economic growth and technological advancement are essentials for improving our quality of life. They also contribute to resource depletion, pollution, and ecological imbalance. This raises a fundamental question: should we prioritize development or environmental conservation? Technological progress often leads to increase of waste generation and pollution, putting immense pressure on natural resources. However, halting the development altogether is also not feasible nor practical. The challenge lies in finding a balance between the progress and environmental sustainability. A notable example is of RA colony controversy in Mumbai. RA is often referred to as the lungs of Mumbai. Is a green areas that plays a crucial role to clear and to clear this land is a major decision. So if we see the metro development, including metro shades and the parking, sparked a widespread debate. While the metro system is necessary for reducing traffic, congestions and promoting public transport, cutting down the trees in a city already struggling with poor air quality is serious concern. A viable alternative is to reforest other parts of Mumbai to compensate for the long green cover, ensuring both urban development and environmental protection. The RA colony controversy in Mumbai begins with the Mumbai Metro Rail Corporation Limited (MMRCL) proposed the construction of metro car shed for Metro Line 3 inside RA colony. The Maharashtra government approved the project in 2014, leading opposition from environmentalists, citizens and activists. The core debate revolved around environmental concerns and need for development. Environmental concerns in the case of cutting down of the trees and harming the land and biodiversity of that area will worsen the air pollution and increase flooding risk, and need for development is also necessary. The metro car shed was seen as an essential for improving the Mumbai public transport system, reducing road traffic and cutting down vehicle emission. As of 2024, the Maharashtra government has reaffirmed its decision to construct the metro car shed in RA despite continued opposition from activists. The Supreme Court had earlier placed a temporary halt on tree cutting, but construction activities have resumed. The RA controversy highlights the larger debate between urban development and environmental conservation, emphasizing the need for sustainable solutions that balance infrastructure growth with ecological protection. The economic growth versus environmental protection debate is also there. A long-standing environmental controversies revolves around economic growth versus environmental protection. Businesses and industries often argue that the strict environmental regulations hinder their economic development, job creations, and also industrial expansion. Conversely, environmentalists stress that unregulated industries activities leads to deforestation, pollution, and climate change, which is ultimately harm human health and economic stability in the long run. A common example is expansion of coal mining and deforestation in developing countries, where economic benefits are prioritized over environmental sustainability. Such activities provide short-term economic gains but result in long-term ecological imbalance and damage, including habitat destruction, air, water pollution, and global warming. The problem of greenwashing. Another major concern is greenwashing, where companies mislead the consumer by falsely portraying themselves as environmental friendly while continuing harmful practices. Many corporations claim to be carbon neutral by investing in carbon offset schemes, but these efforts often fail to reduce actual emission. Greenwashing not only erodes public trust but also slows genuine progress in tackling environmental issues by diverting attention from real impactful solutions. Example, Volkswagen, accused of cheating on pollution tests and modifying engine software. The development versus environmental debate is complex, but it does not have to be a zero-sum game. Sustainable development, where economic growth and environmental protection goes hand in hand, is the key for a better future. Governments, business and communities must work together to implement eco-friendly policies, invest in renewable energy and adopt sustainable practices that foster progress while preserving the planet for future generations. Similarly, while the Environmental Protection Act is a crucial legislation for environmental conservation in India, it has several limitations that hinder its effectiveness. Some of the key drawbacks include lack of effective implementation. Despite the strict provisions, enforcement remains weak due to bureaucratic delays, lack of political will, and corruption. Many industries continue to violate the environmental regulations without facing strict consequences. Ambiguous and overlapping laws. The Environmental Protection Act overlaps with other environmental laws such as Water Prevention and Control Pollution Act 1974 and the Air Prevention and Control Pollution Act 1981, leads to confusion and legal complexities in enforcement. Limited public participation. Although the Act allows public interest litigation (PIL), citizen involvement in decision making is minimal. Many environmental impact assessments are conducted without proper consultation with local communities. Focus on punitive actions rather than prevention. This act primarily focuses on penalizing the violations rather than promoting preventing measures and sustainable practices. This reactive approach often fails to address environmental degradation as its root cause. Weak penalties and compliance issues. The penalties under this act is fines up to rupees 1 lakh or imprisonment of 5 years, often leads to lenient to large corporations. The large companies are okay paying this amount but not accompanying with the laws. Exemptions from large projects. Several large-scale development projects such as highway, mining and industrial zone often receive environmental clearance with minimal scrutiny. Political and economic pressure often leads to loopholes that allow environmentally harmful projects to proceed. While Environmental Protection Act 1986 is a significant step towards environmental conservation, its effectiveness is hampered by weak enforcement, legal ambiguities, and lack of public participation. Strengthening monitoring mechanisms, increasing penalties, ensuring public involvement, and integrating sustainable policies are necessary to make the Act more effective in addressing environmental challenges. To sum up with this, I would like to say the Environmental Protection Act 1986 is a landmark legislation in India's fight against environmental degradation. However, laws cannot protect the environment. Active participation from the government, industries and citizens especially is necessary. Each one of us has a role to play in preserving nature. As Mahatma Gandhi once said, earth provides enough to satisfy every man's need but not every man's greed. In my view, merely having a legal provision is not enough. Awareness, accountability and technological advancement must complement with them, strengthening the monitoring mechanism and encouraging public participation. I also feel law should regularly update to address emerging issues like climate change and waste management and microplastic pollution. As responsible citizens, we must be aware of our rights and duties. We should support and follow eco-friendly practices, raise our voices against environmental violations, and promote sustainability in our daily lives. The government alone cannot protect the environment. Each one of us must contribute. Let us all pledge to be responsible citizens, reduce our ecological footprint, and work towards a cleaner, greener, and sustainable future. The environment is not just a resource, it's our home. We need to protect it. In conclusion, the Environmental Protection Act is not just a legal framework, but a call to action for every citizen. Let us join our hands to protect our environment, not just for ourselves, but for the future generation. As the famous saying goes, we do not inherit the earth from our ancestors, we borrow it from our children. Thank you.
Khushi, thank you very much, because you have touched a very sensitive topic, because environment protection is equally required, but then at the same time development is also equally required. So that fine balance between the development and protection has to be done. And as you have rightly said, the protection of environment does not lie only in law, it should lie with people also. We are equally responsible to protect our environment, because the good we preserve, maybe we can pass on to our next generation. So thank you very much.
Thank you
A small token from us to you.